Point 16 of Webster. The last sentence of that paragraph goes like this. It starts by saying you obviously parties, if they want to, they can do an assignment to be retrospective. And then it says, while such an assignment may be retrospective, which is not the case here, between the parties, it is submitted that having regard to the clear wording of the section, it cannot operate retrospectively so as to prejudice or affect vested rights of third parties. That's the crux. So even if they had actually agreed to do a retrospective assignment, which they haven't, it could not affect, let alone vested constitutional rights of other parties. That's the only point I wanted to make in respect of the points in limine. My Lord, when it comes to non-joinder, I've already explained why the non-joinder in regard to legacy projects. In regard to the SACP, my Lord, the point is very simple. It's like this. Again, let's go to normal law. People forget that trademarks law is actually property law. It just happens to be incorporeal property. So in property law, joint owners of anything, whether they are married people in community of property or partners in a law firm or whatever, have to be joined when that property is being litigated. That's right. Even in the section that my learned friend read of this book, it actually says that in the part he didn't read was that if there are those partnerships, obviously they must be joined. But obviously one of them can assert the rights of the partnership if they were attorneys or whatever. And this has not been done there. When it is common cause that the SACP, as it were, is the joint owner. I'm using that word loosely of the right. Okay. Now, when it comes to the merits, my Lord, I've already made the point. The Lordship, I will beg your Lordship to take into account that the points that I've made are cross-cutting to 34.1a and 34.1c. And for that proposition, my Lord, I wish to refer your Lordship to a case that's not in our heads. National Brands Limited versus Continental Biscuit Manufacturers. Yes, it might be maybe in the other bundle of my learned friends. Okay, it's referred to, yes, it's cited somewhere. Yes, ma'am. Paragraph 17 of that, my Lord, is a paragraph that really shows that all the points I've made are cross-cutting. As court pleases. Page 29 of the other side's bundle, I'm told. I need to tell him that I've paused the 17, my Lord, yes. Yeah. It's a short one, unfortunately. It makes the point, it says the applicant's registration of the trademark conferred on it right to...
It's a different case. I thought you might be referring. It's a different national brands case.
Oh, yes. No. It's not that national brands, apparently, my Lord. Yeah. It's, okay, the neutral citation, my Lord, is of this one I'm dealing with, is 2023 in square brackets. ZAG PPHC 526. My Lord, I On a lighter note, my lord, I wanted to say my stopwatch is on pause now. As a court pleases, my lord. Paragraph 17, I'll just read it out, my lord. Paragraph 17 says, the applicant's registration of the trademark conferred on it the right to protection thereof in terms of the provisions of section 34(1)A and 34(1)C of the Act. The production of proof of registration serves as evidence that the right is clear. There is no dispute between the parties in this regard. And the point I'm making in a slightly different context is that the point we discussed before lunch about proprietorship cuts across, obviously, any infringement, whether it's 34(1)B, A, B, or C. The second point I want to make, my lord, very quickly, is that I will now address your lordship on, of course, your lordship knows that there are many elements of this, of A and B and C. Oh, by the way, this case, just your lordship must just flag this. If you look at their cases pleaded, actually the best case for them would have been under section 34(1)B, which is the one they did not plead. But let's put that aside. On the ones that they did plead, my lord, the common elements are the following: unauthorized use. So if we defeat unauthorized use in terms of 34(1)A by necessary logic, we're defeating it in 34(1)C. Secondly, in the course of trade. If that case is bad, it's bad for both 34(1)A and C. And thirdly, in relation, I'm paraphrasing, to the relevant goods, is that one that says for the goods for which, in relation to which the mark has been registered. So even if you don't go to all those things about the well-known and so on, just take these three elements that are common to both sections. We've already started with proprietorship. Unauthorized use, my lord, means surely that in the situation where they had abandoned, in the sense that I explained earlier, then the use, and it's also in Webster, the use is authorized in that sense, implied. In other words, what Webster says is that authorizing use can be done expressly, obviously, but it can also be implied from a waiver or an estoppel.
How does that assist you, Mr. Porter? Because there is no evidence of authorization at the legacy or by the ANC. So what do you think that happened?
No, my lord, I'm sorry. That's the wrong way to approach it, my lord. The onus is on the plaintiff, on the one who's alleging. Yes, they must prove that it's unauthorized. Not I have to prove that it's authorized. No. They must prove that our use is unauthorized. And I'm simply saying our use cannot be unauthorized when they have abandoned that right. That's the first submission I make. Because that act, it's conduct, if you like. That act means that we could do what we like because they would have proceeded. They would have otherwise proceeded with their appeal of the commission decision. That's the first point. The second point, my lord, is a more subtle one, and it is this. I ask it as a rhetorical question. Can we really say in constitutional South Africa that that an act or conduct which is authorized by the IEC, in the sense it is constitutionally authorized, if you like, of the registration of a party, and which gives you exclusive rights, is unauthorized? And it's a point, my lord, that I'm saying just by operation of logic, you can't say such an act is unauthorized. And my learned friend says that he doesn't know why we claim exclusivity over the mark. But that exclusivity follows as a matter of law, my lord, because in Cope, which is the first case in your lordship's, my learned friend, Mr. Skakane, will deal with it in another context. Paragraph 15 of the code, page 3 of our bundle, my lord. Page 3 of our authorities bundle. There it says the following, my lord. Mr. Ginsberg pointed out correctly that in terms of Section 16(1)(b) of the Act, that's the IEC Act, COPE will, once registered as a political party, under that name, be entitled exclusively to use the name Congress of the People as a name for a political party, not for Coca-Cola. That council submitted will be in the long-term result in people identifying only COPE with the 1955 Congress, whatever. I tend to agree with Mr. Pakrin for COPE that we are called upon to judge that case on the facts as they stand today and not as they might stand in the future. So what the court was saying in the first part, my lord, is that the registration, which we now know is not hanging because it was confirmed yesterday in the judgment, at least gives the MK party the exclusive right, when we're talking about political parties, the exclusive right to use that name as a name for a political party. So that's the vested right that I was talking about. So that vested right cannot be defeated by the Trademarks Act, because that would be turning our entire legal system upside down. You'll be saying a constitutional right can be defeated by a statute. It's the other way around. A statute must be construed in line through the prism of the Constitution. So that's the authorization point. The second point, my lord, is in the course of trade, and your lordship alluded to this. In fact, I'll condense this with the next point because there's no time. Your lordship asked correctly to be given a copy of the register of the classification. Well, I can assure your lordship that you'll find nothing in the classification, class 41, other than what is in that certificate. Class 41 simply says, and I'm reading from the schedule to education, semicolon, providing of training, semicolon, entertainment, semicolon, sporting and cultural activities. That's it. And that's as it appears in the registration certificate.
Where are you reading from?
Your Lordship?
The reference that you
Yes. Yes, no. I think the better one, because I see your Lordship has got Webster. I'll give you the Webster reference, my lord. If your Lordship goes in Webster, it will be in the annexures under appendices. And your Lordship will find it at Appendix 2-41. The heading is Services, and then Class 41 says Education, providing of training, entertainment, sporting, and cultural activities. That's it. So this story about congresses, which I don't even understand, it really is neither here nor there. The point is that the use must be in relation to, must be in the course of trade and in relation to the goods for which the mark was registered. And we know what the goods for which the mark was registered. It is those things. MK Party has got nothing to do with any of these things. The services that MK Party offers, and goods, by the way, don't feature. If you look at prayer 2, my lord, of your notice of motion, they only talk about services. But suddenly in the affidavit, they talk about goods. They were right to only talk about services in their prayer, because MK Party does not produce goods. It's in the process of producing services at best, if you even think that this thing applies to political parties. And those services are the services of political activities or vote catching, or whatever you call it. But the point I'm making is simply that those are not in that class. Then the last point, my lord, is that the issue of exclusivity, which is an essential element of the entire trademarks issue. The non-exclusive, and I go back to the SACP point, whether it's SACP, I know the other things are no longer here, Congress of Democrats and what have you, but at least SACP, MKMVA, there is common cause that they've used the logo. And my learned friend, Mr. Marriott, before he sat down, made the cardinal mistake. You don't say you have to compare the trademark of the ANC, let's assume it is, with the logo. No. It must be you compare the trademark with the trademark. So you have to show that MK Party is using that logo as a trademark. Where is the evidence for that? That's why the concept of use as a trademark is itself an element, Your Lordship knows, both for, it's arguable for 341C, but for 341A definitely use as a trademark. So you'd have to show that the MK Party itself is, you can't say I'm comparing a mark and a logo. So the situation, my Lord, that you have at paragraph 13 of their heads will never arise in the legal sense. Because there you have the logo of the MKP, and then you have the trademark. You'll see that paragraph 13 of their heads. This is where the deviousness of this whole case is about. Because there you have a trademark, and then they say the infringing mark. But who said that was a mark? It's the MK logo that has the Umkhonto weSizwe, the MK, and a warrior that is stabbing Gwaza like this, as opposed to the other warrior who's pre-Shaka stance. But the most important thing is the green, is the green background, which Your Lordship pointed out, and the name, the words Umkhonto weSizwe, but it's not a mark. When it comes to Mr. Skakane's section, then the case is even worse, because there you would have to, in passing off, put the logo of, or rather the registered mark, and the ANC logo, which we all know, which you'll find at page 33 of their founding affidavit. And which voter in there, unless this is an insult to us as voters, to think someone will go into a voting booth and see the logo of the ANC and see the logo of Umkhonto weSizwe and have voter confusion. I think the confusion is just on their side now. So those are our submissions, my Lord. This is, again, it's a question of time. It does not mean all the other submissions we've made in our heads about deception, well-known, and so on, stand. But I thought the best way to cut the time is to take the elements that are cross-cutting with 341A and C. Not to mention the laugh-it-off case, my Lord, which clearly says that for laugh-it-off, you must substitute freedom of expression. Well, in terms of the utterances, you don't even have to substitute. Freedom of expression and freedom of political rights. So laugh-it-off basically says you can't use the anti-dilution clause, 341C, to defeat the constitutional right to free expression. Similarly, we're saying you can't use the anti-dilution provision to defeat vested political rights. So that case is on all fours with this situation. It's not this cannot be seen in a vacuum. It must be seen in this section, which is ending where we started. This case must be viewed from the prism of the political rights vested in Section 34. As God pleases. We're indebted to Your Lordship. Sorry.
My Lord, no, it's fine. I think I would need your assistant, Your Lordship. I have 4 sections to address the court about, and I do not want to waffle, and I don't have enough time to do so, to address you on the 4 issues. I have literally 7 minutes. I would like guidance from the court. I had prepared to argue for 45 minutes per agreement. It's going to be very difficult, but I will stick to your 15 minutes, Your Lordship. It's not your fault, it's ours. Your Lordship, there are 4 topics that I thought I should help the court with. One, I'm going to be brief about it because there's no controversy. The first one is the history as it relates to passing off. as a common law action. The second one really is passing off itself as a legal concept. What exactly is it? And how does this case fit in it? And then I was going to deal with the abuse of process flowing from there, but I think I won't bore the court with that. My learned friend, I think, dealt with it. But to the extent that I can address the court on these four, let me start with what I think I can do in the time I have. But there are two domains of law we're dealing with. And this difficulty that you see is because we're in the domain of Section 19 rights, which are political rights. And there are consumer rights, or what you would call Section 22 rights. Those are the two domains. It's addressed better in the jurisdiction point, but I just thought I should raise that for the court to assist the court. I cannot take you far, but I'm going to take your lordship to the authority that says, when we get to passing off, that says you cannot, because of the difficulty you've seen my three learned friends debating, not knowing where they are about which battlefield are we in. And that authority, it's in Webster and Page. It actually tells us, it's an old English case. It says that is why this confusion you see, that is why passing off that action is difficult and unsuitable for cases of a political nature. It's a case of kin. I'm gonna have to give to your lordship. Let me just. You will have to really bear with me. It's difficult to squash what I was to do in the time I have. I just can't. Anyway, what that case tells you, I'll get to it, because it's about when I reach passing off. But let me start with my first topic of the history, to the extent that in introducing passing off, my learned friend made an attempt to describe the history of Umkhonto weSizwe. And I do this briefly because there is no dispute about what it was. And no one can tell us that the ANC was not associated with MK, and no one can tell this court that the ANC was not to give political direction to alliance partners in Umkhonto weSizwe when it started. But of course, history gets lost, my lord, in the wicked wit of lawyers and politicians, and history disappears. It's true that the ANC has played a very dominant role in giving political direction in the struggle in the 60s. And if you periodize it, it's the only way you're going to understand this, is to periodize the history of the ANC, even starting before it was formed to 1910, 1949 when it radicalized the youth, and 1955 when the Congress of Democrats and other parties come in, and then it leads you to 1961, because it's a different kind of radicalization of a decision by those alliance partners, not one, by all of them, to create an army. And it's not an army, if you look at the manifesto, it's the army of the people, founded on the basis that the settler colonial state at the time had become brutal and violent, and it sought to defend them. And my learned friend says, we've always known that the ANC controls the MK. Well, that's of no moment. Everyone who's involved was a South African knows that for each alliance there's a political leader, there's political leadership. And one of the distinguishing features of Umkhonto weSizwe was two things. One, it was not a regular army. Two, it was preceded by a group of people, South Africans, they call them combatants drawn from the people, who would independently defend people in different places in order to defend, not the ANC, to defend the people and the struggle against the colonial, settler, racist state. And all of these parties were important. I'm saying that summary, and I'll say your lordship must look at the manifesto because the ANC has quoted it, and it's correct. Where my learned friend gets it wrong, he uses non-legal terms. It belongs. No one can deny that the ANC had a hand, and I think you'll find that in paragraph 33 of the replying affidavit of the ANC. It's correct. No one should stand in this course and deny what the ANC was in the struggle within its alliance partners that formed this. So to the extent that here was an army that was a guerrilla army to defend people, the second aspect of it was that it was an army that fought what they called, and it's in the manifesto and the code, a people's war. And it's for that reason, as I close, that my learned friend talks about the fact that at some point there were divisions about whether or not it was the right move. It's because this, you look at the manifesto of Umkhonto we Sizwe, you look at its oath, it tells you this was a calculated, noble move by a group of people, not in the ANC, but in the Alliance Congress, to support a struggle that was waged and led by the ANC. And in that way, that kind of political control, which is correct because it sought to give direction, so that all combatants fall within the political prescripts of a particular ideological line. It was correct, but it does not translate to exclusive ownership, which is what trademarks and passing off are about. Let me then move. We don't have time to know what MK was because I think we all agree. If your lordship can look at paragraph 19.3 of the answering affidavit, you will see that what we're dealing with there is, I may be wrong about, but at paragraph, that paragraph states, I think it's 19.3 or 19.20. I'm gonna find it now, my lord.
117.
It's the paragraph to which the ANC replies in paragraph 33. I just don't want to page around, but it's there.
Yes.
No. No, my lord, it's not this one. Can I come back to you? I'll give you the specific, but it's probably 19.17. I'll find it, but I'll tell you the gist of the two. One paragraph in the answering affidavit of Umkhonto we Sizwe says that this was not formed by one organization. It was a multi-organizational endeavor. Yeah, no, it's fine. I'll come back to it. I don't think it's that one. And paragraph 33 of the ANC's answer, reply to that, is that they admit that this army was not formed by one organization. That's the point I'm making. And I'll find the reference for your lordship. I'm told it's paragraph 19.5. It says the ANC never enjoyed exclusive ownership. This is not in dispute. It's not in dispute. What you have is nuances that fail to understand political direction and ownership since this 1961 and later. And so what is being said by my learned friend, Mr. Marot, is not wrong, but it's actually a mistake of mischaracterizing a relationship between a party that gives political direction. And you'll find that with ISIS, you'll find it with Hamas, you'll find it with the PLO, and all armies of people that are occupied and oppressed take political direction from somewhere, and that does not mean ownership. It has never. Well, let me then move quickly to the second topic. So the point I'm making there is that there is no sign, no evidence that there was exclusive ownership. But in our heads, we've dealt with the principle of passing off. But let me just start with what Judge Harams says in a case that I think locates these kinds of disputes as disputes that must be seen within the prism of the Constitution. And once you are there, you must then decide whether you are dealing with trading in goods and services, which is of commercial value, or you're dealing with Section 19 political rights, which leads you to what my learned friend, Mr. Marot, correctly calls it the consumer, in his example, is the voter at the ballot, booth. That was his answer to your lordship about what is the confusion. He says it's the voter at the ballot booth. And he's right. No one who's honest can deny that this dispute, if it's a dispute, is about that. Now, if that is the case, then this dispute of passing off, this dispute about confusion, is located in Section 16 of the Electoral Act as a special, because it takes it to the Electoral Court as a specialized court. And so, what exactly is the ANC complaining about? Well, in paragraph 22 of its affidavit, the ANC says, given that we are in electoral environment, that tells you which category of rights we are in. Time is of the essence. Of course, they say this in the context of urgency, which they haven't addressed.
So you're reading
Paragraph 22 of the founding affidavit of the ANC.
22.
Paragraph 22.
That's page 13.
It's page 13, my lord. It's fine, I've got it here. Now, it may be said in the context of trying to justify that this matter is urgent, which we all know is not. But it tells you, coupled with my learned friend's answer to your lordship, it tells you that the environment that is at issue in these proceedings is the electoral environment. And therefore, it locates it. This is some kind of lack of right and wrong forum. This battle we're having today is in the wrong battlefield. It neither belongs in the electoral court because that's been decided, nor here, if you want, because it's actually a battle for political mind share, which no court can determine. That's what it is. And that's why your lordship and my learned friends are battling to locate it. That debate you were having because this is not a battle for a court. It's a battle for political mind share, and it's a legitimate battle. It just happens to be in this court because South Africans have a tendency to come to court as an extension of political gains. But it shouldn't be, because it's a battle for mind share, which is legitimate between political parties. And so it says, deliberate acts, this is the paragraph, deliberate acts to cause voter confusion, erode free and fair elections. Now it tells you the realm in which we are operating, the domain in which we are operating. And you will see that you put aside the fact that this point, as I said, is made in urgency, in the improving agency. Trademark law deals with trade in goods and services, strictly. It's in the area of commercial law. That's trade. That's why everyone is battling to tell you what they sell. What are the goods? What are the services? I hope it's not the people. There are no goods and services in this regard because it's in the domain that is placed elsewhere in the Constitution. And so this battle has to do, consequently, with the fact that this battle doesn't belong here. Now, of course, by its own version, the ANC, as I said, we are in the realm of Section 16 of the Electoral Act. That's where we are if we are to go to any place. If the courts are a battlefield, it's not this court. And let me say, services is defined this way, to include offering for sale or the sale of goods in the retail or wholesale trade. That's the definition in the Act of services. So what exactly is the definition of passing off then? What is it that essentially tells your lordship what passing off is? Because we've been throwing this word around. And what is its definition? Well, the ANC claims in its founding affidavit that there are two elements. It's reputation. In the English law, they talk about goodwill. And they also say it's about misrepresentation. And they make this case in paragraph 90 to paragraph 109 of their founding affidavit. It's paragraph 90 to 109 of the founding affidavit. And at the heart of that claim is what it says. It says, since its inception, the ANC's Umkhonto weSizwe has been known as such and has never changed. It means belonging. In this regard, the ANC relies on various posters to make this point. And these posters of bearing the MK symbol, you will find them in the SSCP conference posters. You will find them at the funeral of different people. So that takes us nowhere. But here is the punch that I think tells us and settles this question at least. Is the ANC's admission, the MK party says that the decision to establish Umkhonto weSizwe was not an organizational one. I think it's clearer in 19.10. And the ANC says, and I quote them, it's page 224 of the papers. It says, the applicant does not take issue with the historical context as narrated. That's the end of the dispute about the history. It should end there. That's their version. Can I cite a couple of cases that I think define this without reading the definition of passing off?
You're getting close to your time.
I'm gonna end now. As I said, it's not the court's fault. The case, my lord, is this. It's Capital Estate and General Agencies, Pty Ltd.
Are those in your bundle?
It's not. I thought about it as the points were being made, but I'll give the full citation. It's not. Two cases are not in those because my learned friend was making points that I think are contradicted elsewhere, and I found these cases. The Capital Estate and General Agencies, Pty Ltd. versus Holiday Inns Incorporated. It's 1977 to SA 916. A, it's the appellate division. Now, of course, my lord, we all know that passing off is an action designed to protect a business against misrepresentation.
What paragraph have you
No,
been?
no?
What paragraph?
No, I'm saying this as a tried principle. That's what it is. But the court says this in the Rabbi J.A. then as he was then says, the wrong known as passing off consists in a representation by one person that his business or merchandise, as the case may be, is that of another, or that it is associated with that of another. And in order to determine whether a representation amounts to a passing off, one inquires whether there is a reasonable likelihood that members of the public may be confused into believing that the business of the one is or is connected with that of another. Close quote. It's as I said, it's 1977 to 916, or it's 918. Thank you. All right, there's another case with this. I won't read this. It's an old case that is quoted in that one. It's Polanski Brothers, Ltd. versus L&H Polanski, 1935, AD 89, from pages 97 to 113. The definitions there tell you that we are in the realm in which the ANC, in its current case as pleaded, cannot locate itself within. What they have not done, he quoted two requirements. Said to your lordship, there must be reputation, which is true. There must be a misrepresentation. But of course, my lord, there must be damage to that. There must be damage or apprehension of damage. But how do you do that? You do that by providing sufficient evidence to demonstrate that damage has happened as a result of, let's call it the misrepresentation, or damage is apprehended. Now, my lord, here is a summary of this case. This is not a case of association. It's actually a case of dissociation from the ANC. There is absolutely no legitimacy in arguing that MK Party seeks to represent itself as the ANC. It wouldn't make sense. In fact, the opposite should be true. And therefore, if the opposite is true, the case of passing off falls flat. Because you must seek to be seen as the other for passing off to happen. Or you must seek your goods to be interpreted as sourced from the other. And that is the end of the passing off. My lord, just for you 1 minute left about the three elements of interdict, which no one has dealt with. The debate your lordship was having with my learned friend, Mr. Mpofu, about whether there has been a registration or whether there has been exclusive ownership is about a clear right. Not a prima facie right, a clear right.
The applicants are asking for final.
Yes.
The applicants are asking for a final.
Yes. They ask for a final interdict. Means it's not a right you must claim that you could guess that it's there. It must be a clear right. And your lordship was at pains to point out that there was no shred of evidence that could satisfy just that requirement. The second one is what I've just talked about, whether there is damage. And that, of course, coincides with the requirement of what a passing off must be for a party to complain about. That there has been, I have a reputation, and there has been a misrepresentation in order to damage my reputation, that or goodwill, as they say in the English law. That is the nature of passing off. There is no evidence for damage caused or not caused. I don't believe there's an ANC member who will confuse Umkhonto Wesizwe Party with the ANC. It is not true that members of the ANC can be confused about the face of Cyril Ramaphosa on the ballot paper and that of whoever will be on the one form controversies. It's actually a statement that is condescending in nature to the voter. And if that is true, the case for passing off doesn't work, and the second leg of the 3 requirements for an interim, for a final interdict. And we don't have to get to the other one. Even if they do have an alternative remedy of what they would do if they went to the right forum, the right battlefield, with the right arms. And I've said they did. They went to the commission with this very complaint. But in any event, as I said when I started, my lord, the battlefield for this is not here. It's actually people respecting Section 19, which allows everyone to compete for political space. It is just said that people are in this room fighting about political space that they now have, but don't want others to have. But generally, Section 19 was to make sure that we can exercise that political space and use every non-violent weapon we have to fight for political mind share. And that's where the battle is. And if parties could stop going to court and we fight about jurisdiction and compete where they must to persuade me that they have not forsaken us, they've not forsaken the people, all of them. No court has jurisdiction to deal with political mind share as a battlefield. And those are my submissions. I'm sorry if I took more. I think I took your 5 or 4 minutes.
30 minutes.
So I'm very sorry. It was difficult to do this. Thank you.
Thank you, my lord.
It's actually 30 minutes.
My lord, I intend to deal primarily with the jurisdiction point, the locus point, and then respond to the passing off case. My lord, on the jurisdiction point, my learned friend focused on the objection to the registration which had been considered by the Commission, the Electoral Commission, and he said that the ANC had elected to run its trademark fight, basically, under the Electoral Act. He accepts that the Bloemfontein leg of the case was irrelevant. But his argument depends on 2 things. The first is, does the Electoral Court have the power to determine trademark infringement in passing off cases? And secondly, did we in fact, or did the ANC in fact, run a trademark infringement in passing off case before the Commission? As to the first of these, whether the Electoral Court actually has the power to determine trademark infringement in passing off cases, it plainly does not. What it does is it looks at the 2 parties' names as registered before it and their logos as registered before it and decides. So it'll look at ANC and Mkhonto Sizwe. And I've made it clear that that's not our case. And why does it do that? Because that is an electoral matter. But it does not have the power to determine trademark infringement in passing off cases. And that is why it says at page 60 of, why the Commission said at page 60 of Bundle B, in paragraph 12, said, it is noteworthy, 60 of Bundle B,
Bundle B meaning the IEC bundle?
yes, I apologize, yes, 60, yes, it's the Electoral Commission's letter, the end of it, paragraph 12. Furthermore, it is noteworthy that the protection in terms of section 16(1)(b) of the Commission is only afforded to those political parties that are lawfully registered with the Commission in compliance with the provisions of section 15 and 16. That's entirely consistent with what I say to you now, which is all that they look at is what's registered before it. That's why they weren't willing to entertain legacy projects, and that's why they weren't willing to entertain any debate about common law rights in Inkonto Sizwe or registered trademark rights in a logo. It's got nothing to do with them. What they look at is this party registered that is coming to object? And as part of when they consider the new application, they will look at, does the name that is now sought to be registered, is it similar to one that is registered before us? That's what they look at.
That argument takes you past legacy trust because it doesn't fall within the ambit of the Electoral Act. They're not a registered party. And what about the ANC?
The registration to which the IEC will have regard is their registration as a political party with the ANC. The IEC will not have regard and will not entertain disputes. Let's take it out of the trademark. Let's consider the passing off. The IEC is not going to entertain a debate as to whether the ANC has common law rights in a brand or a name. It has no power to do that. It's not going to. You, as the ANC, you don't submit every trademark right, every common law right in a brand that you have and ask the IEC to determine whether that is going to be infringed by the registration of this name. That's not the IEC's job. That is not what they do. They don't have jurisdiction. They can't determine whether there's a common law right.
Let's go back to what the ANC asked the IEC, and that's found at page 48 and 49.
Can I say this? I accept whatever the ANC may have asked the IEC to do. It doesn't mean that the IEC has the power to do it.
The issue that I was hoping you'd clarify
Yes.
is that that was the basis, page 58, the letter written by the Secretary General of the ANC to the IEC. And I raised this because it was raised by Mr. Nkoku, particularly paragraph 2 on page 49. He says the issue of trademark was raised as a ground of appeal by the ANC, only to be later abandoned. Now, I hear what you say, that the electoral court and the commission don't have jurisdiction in terms of the trademarks. But what will I make of paragraph 2? And everywhere else is on page 4?
This is not unusual. You might go to a court, and the court says,
Like an application.
I don't have jurisdiction. You say, actually, you know what? I agree with you. I'm going to go to the court that does have jurisdiction, and here we are. So the fact that the ANC started on a path.
Yeah, but you take it, you go down the path, but you stop halfway in between. And what I'm asking you is what became of the grounds noted in page 49? It's not quite clear to me from the
Well, the ANC was in the wrong field. They were before the IEC trying to argue a trademark case, which is the wrong place to be. They clearly realized they couldn't proceed, and an appeal or a review would be utterly pointless because they were in the wrong place, and therefore they come to the right place. You can't now say, well, because you realized you were in the wrong place and went to the right place, that you've given up your rights. That's all right. And they moved swiftly. They, within 6 weeks of that decision, there was these proceedings were launched. Just on that topic, my Lord, I've been criticised for not having dealt with urgency. My Lord, no disrespect was intended. It was the first page of my notes, and I skipped straight onto the merits when the allocations were made. There isn't the allocations of time, should I say, but we have debated the merits all day, and my Lord, the way of these things ordinarily, if the urgency is a problem, I anticipate that I would have dealt with it. We thought we were here on a special allocation. The matter's been fully ventilated, and we felt that, my submission is that the matter ought therefore to proceed. As I say,
it proceeds.
Yeah.
But I think the point made by Mr. Mpofu is that the ANC has brought this matter to court on an urgent basis, and therefore to that extent, you have to show why. You
Well,
have to jump the queue.
yes. Well, certainly we. The point simply is that the test for urgency is whether you can get adequate redress in due course. And the elections are just weeks away, and clearly the ANC will not get adequate redress at a hearing after the elections are held. To the contrary, Mkhonto Sizwe will have been allowed to achieve exactly what it set out to achieve in the first place, which is to ride on the coattails of the ANC's heritage. And that, a hearing after the elections will not remedy that harm. So that is the fundamental test as to whether the matter is urgent. The matter wasn't prosecuted with extreme urgency. The respondents were given adequate opportunity. They've obviously prepared extremely well. They prepared a full answering affidavit in 3.5 weeks.
The basis on which a party engages the jurisdiction or engages support on the basis of truncated time period, you've got to set that out. That's an essential ingredient as to why the court should hear your matter as one which is urgent.
Yes.
And you've got to, and it's right that you've got to account for all of the impeding auxiliary. And that's, as I understand the argument.
Well, and in a sense, that has been canvassed today, because just at the debate we were just having, the ANC followed a path before the IEC, realised they were wrong. When that decision came in the end of November, that said, actually, we only entertain political parties, and the implication of that, as the ANC understood it, was, well, trademark fights don't belong here. They moved with.
We just have to hear in the paper.
Well, my lord, the urgency is dealt with in the papers. The point was made, my lord, that the elections are just around the corner. They've got no option to approach because page 10, my lord. It is said that it's got no option because its existing reputation to Mkhonto Sizwe, as well as the name, is being eroded on a daily basis. That is often the case in trademark cases, and often the reason why they are dealt with on an urgent basis. Because, of course, a hearing in up to a year or 2 years' time provides no real redress at all. He said in paragraph 20 that the elections, it was said, would be within the first 4 months. It's within the first 5. As such, if the ANC approaches this matter in the ordinary course, the damage which Mr. Kamala and former President Zuma do by their pronouncements would be irreparable, and they go on to explain that every day that passes is causing more harm. That is the case for urgency, and with respect, those are good grounds we submit for bringing an urgent application. There's no base. There's the matter cannot get proper redress in due course, and on that basis, it ought to be heard as a matter of urgency. My lord, I was just finishing the. I think I've made my points on joinder, my lord. On locus, the ANC's locus standi arises from the assignment for its trademark case, and on the basis that it owns goodwill for its passing off case.
And then we're dealing with page 256.
Well,
Is that the
yes, I will deal with page 256, my lord. I don't want to go straight to 256. I would ask you, please. My learned friends relied on a paragraph earlier in Webster and Page. He then took you to paragraph 11.16. If I could do the same, because it's. What it says in the first paragraph is a registered trademark is a species of incorporeal property. 11.16 Webster and Page. Thus, the transfer of proprietorship takes place in terms of a transfer agreement. Registration of an assignment in the Register of Trademarks is not a prerequisite to the transfer of rights in a registered trademark. The recordal of an assignment of a trademark is a recordal of an existing fact. It's fundamentally different to the transfer of land. The point simply being that we don't need to be registered in the trademarks register to have the proprietorship.
let's say I'm looking.
Yes.
What's the best case scenario then in terms of the assignment?
It has to be recorded, I think, within 12 months. It's already been applied for.
As far as locus is concerned.
We've pleaded the assignment. We are the
No,
proprietor.
So, as from what date?
From September, the effective date
So that would be your best case scenario.
on the trademark. Yes. So, my lord, just on that point about whether you need to be the registered proprietor, there is nothing in the Act which says that only a registered proprietor can bring a trademark infringement proceeding. It doesn't use the word registered proprietor.
So 34.3 says that where a trademark registered in terms of the act that's been
Yes, the trademark is registered. Doesn't
then surely, Mr. Barrett, it can't be that if a trademark is registered in the name of legacy that an entity like the ANC could bring an application, whether it's in this court or in the IC for particular relief. You've got to show direct and substantial interest.
and you do that by pleading the transfer of the right, which is what I've just read to you. You don't have to plead that you've registered the recordal yet. That is just a recordal of an existing
I'm
fact.
talking about the report.
Yeah.
I'm talking about the assignment. So we go back to September.
Yes.
As I understand the argument of the respondents say that the ANC is not the proprietor, registered proprietor.
Well, there's a big difference between those two.
Okay, go ahead.
A proprietor is the owner of the mark. The ANC was the owner of the mark. That's what I've just read to you from Webster and Page. It was the owner of the mark from the effective date of the assignment, as soon as the assignment was
Correct. That's
so-
why I asked you,
Yeah.
what is the best case scenario for the ANC? And
Yeah.
you accepted September
Yes.
2023.
Yes. So there is no requirement, and I repeat, that you have to be the registered proprietor, registered in the trademarks register, in order to institute infringement proceedings. the requirement, you need to be the proprietor. And the difference is that a proprietor has taken assignment or transfer, but a registered proprietor is somebody whose name now appears in the register as the proprietor. And I don't have time now, my lord, but you may want to contrast the absence of any requirement to be the registered proprietor to bring infringement proceedings with other provisions of the Act which clearly stipulate that you have to be the registered proprietor. Sections 23, 25, 30 all refer to things that only a registered proprietor can do. 23, 25, 30.
Well, I mean, if one just glances at section 23,
Yep.
it deals with the amendments of the register. You'd have locus to do that only if you were the owner of the mark or the particular entity that's been registered in the trademarks register, not so.
Well, you can only do what you can do in 23.
Yeah, if you are the registered proprietor.
Sorry, before I can.
If you look at 23.2. Because that's on the basis that the right already vested.
Yes. Sorry, my lord, I just. Yes, my lord. You only the registered proprietor can amend the register. Yes, but you don't have to be registered. You don't have to be the registered proprietor to bring an infringement suit. That's my point. My lord, as to page 256, that is a form which is it's a prescribed form. It's again part of the regulations under the Trademarks Act, and it's a standard form. When you fill it in, all you are filling in is what's appearing in the register at the moment and what you would like the registrar to change it to. As Webster and Page say, you are simply recording an existing fact. Nothing about the form changes the existing facts. Then my learned friend, when you asked him about the effective date, and the import of that on the Form D6, he answered you by saying, but yes, he'll take that into account, but in September they had started using the mark before. But of course,
They're registered
that
with the IAC.
well, yes, my lord, but that assumes that the registration with the IAC trumps all trademark rights, which we've been through, and it doesn't. And the point about the continued use is that it is a continuing wrong. Every time you put up another poster, every time you use the trademark, it is another infringement which warrants interdictory relief. Yes, there's nothing that the ANC could have done about infringements which occurred before September, but this case is about all the conduct that happened after September, including in December.
Mr. Madden, can I ask you to look at the notice of motion?
Yes.
What exactly, and I raised this with the junior, Mr. Ramakar, what is the ANC seeking? What's the practically?
The practical, thank you, Lord. The practical effect is that the MK Party will not be entitled to use the logo, any mark that looks like the warrior device that you see on page 3. And they won't be entitled to use the name Nkonto Sizwe and the related logo, which you then see at page, also on page 3, or anything similar to it. The practical effect is that they will need to change their name and change their logo, of course.
Their defense to that, just to encapsulate it in a nutshell, is that apart from your arguments as to why they chose the name, etc., leave aside all of that, their contention is, well, we got to go ahead from the IEC.
That's the,
You're saying that's not good enough because that doesn't yield trademarks. But at the practical level, the order that you asked in this court to make is effectively that all posters should be taken down or delivered up to the ANC, and that the party as it is currently has to disassociate itself from that and go back to the IEC and commence the process for the, what is it, renaming of the party.
correct.
16 big A's.
That's the practical effect, yes.
And that has to be achieved within a period of about, is it 2 months?
Well, I mean, obviously it's not overnight. I mean, there's no provision for time in the order.
No.
Yeah.
I'm talking about the IEC. I can't prescribe to them what to do.
No, but
They're bound by the act.
we can't control how fast they go to the IEC, but certainly once the IEC has it, it will be processed. Yes.
And the consequence of that is that if I'm inclined to make an order in favor, that all political activity by the MK party ceases.
No, my lord, because they could continue under another name. So
But you can't, as I understand, you can't campaign under a different name until you've been authorized and registered to do so by the IEC.
there would be a gap, but I mean, I don't think there would be they still remain registered. It's just under a different name. So I don't think there would be any bar against campaigning. They're still registered.
Well, you're registered as what?
Well, there would be a name change process undergoing, and they would say, well, we've applied to change our name, and we're campaigning under this banner now. That is the effect.
Anything else, Mr. Mayor?
Lord, I had just a few points on Mr. Mpofu's submissions. 3 short points, my lord. My learned friend referred to unauthorized use. That has been pleaded. I don't know if you need the references, but it's paragraph 84 and paragraph 106 of the founding affidavit. 84 and paragraph 106. And this relates to something we've just debated. When the Act says unauthorized use, it means authorized by the proprietor. The IEC cannot authorize the use of another person's trademark. And then third point, well, you asked, my lord, for the full NIS classification in class 41. I have it for your lordship. What appears in Schedule 3 are the class headings, but as the judgment in the judgment that I read to you explains, in Leonard Dingler it's part of the NIS classification, and the NIS classification goes down into the subcategories that I explained during my opening address, and those include, as I made clear, the organisation of congresses and the like. Excuse me, my lord. I've now given out both of my copies, but it's down on the second page. I think it is alphabetical, my lord. It's just as from memory. Can I borrow this? Sure. I'll mark it for you. It's 410045 and 410046. On the second page, middle of the page. Maybe just above middle. You can see congresses, conferences. Maybe we can just mark it for you. Yeah. Yeah.
I don't want to make a finding on something that I don't raise.
Yes.
But surely you've got to read arranging and conducting of conferences and congresses in the context of what the heading is, rather than sub. In terms, you've got to read that in the context of education, providing training, entertaining, sporting, and cultural.
Well, I mean, politics, cultural. My lord, it's. I mean, I think. I think the distinction is rather fine. And if you look at the dictionary definition of Congress, it is political. That is the dictionary definition. It also refers, for example, to political speech. That is another one of the goods listed. Here we go again.
Okay.
Political speech. I think it is. Lord, I think I'm right. I certainly found it in the heads, and I've got a link to it there. Maybe I can just check that, Lord.
Very well. You do. And the sensibilities through to my register and through to the others.
Thank you. No, I think those are my submissions. Thank you.
Thank you, my lord. I'll be.
You don't have the right to say but what arises that you want to reply to?
Yes. Well, my lord, that three broad points. The first one is obviously the issues that were now raised for the first time in reply regarding agency, which is not how it should be done. But
okay, so urgency. What else do you
yes,
deal with?
my lord. Then there's the issue. There's there's a what one might call a cross-cutting issue about it has to do with locus. The point that was raised by.
5 minutes.
That's fine. That's fine. Okay, wait, my lord. Put the clock. Well, my lord, on urgency, I just want to take your lordship to the point that was made by my learned friend, Mr. Skakan. Everything they say, my lord, culminates in paragraph 22 of their founding affidavit, which you will find at page 13, 1-3, my lord. And, you know, they say when you are in a hole, you must stop digging. But so that digs them really further down the hole. Because what it says, my lord, is that it shows that this matter, what this matter really is about. Given that we are in an electoral environment, time is of the essence. So they are here because of the elections. Each day between now and the election is important for any party to be able to campaign effectively. So they're here to limit our Section 19 of the Constitution rights to campaign. And then they say deliberate acts to cause voter confusion. We spoke about that before lunch. This case is about voter confusion, not any old confusion out there. Erode free and fair elections, Section 19 of the elections again. Deliberate acts to cause voter confusion, erode this, and then they say this is the coup de grace. It is for that reason that the ANC requests that this court must attend to this matter urgently and expeditiously. Why are we here? That covers exactly the basis for this. It's all Section 19, it's all Electoral Act, it's all in the heartland, quintessential in terms of paragraph 40 of the CAM decision, that this is an electoral matter. And that case says all electoral matters are exclusively to the jurisdiction of the Electoral Court. The second point, my lord, is just to round off, your lordship asked a pertinent question. What do these people want here? What is the ANC wanting to do? They say, and it says the practical effect is that they will have to change their name and change their logo. That's what Mr. Marriott says. Well, your lordship correctly points out, and this links to the issue of urgency. It says, okay, now, so we have a party, my lord, that has a cause of action that arises on the 9th of June, 2023. Waits for 6 months, does nothing. On the 9th, exactly on the anniversary, 6 months anniversary, on the 9th of January, then they approach this court. And your lordship is quite correct. It's not just the question of, in due course, the test for urgency is the one that my learned friend is running away from. Is the urgency self-created? That's the test. They wait for 6 months and they do nothing, and they expect umkhonto wesizwe now to rush to a month before the election, when they've already they've already campaigned due to their laxity, to now suddenly change their name. And do what? How is that going to assist them? Okay, if we call it umkhonto, full stop. Are they going to be happy? Because that's the, or umkhonto kaZuma, maybe that's one that they want it to be called that, or something. It will make no practical difference. So they're here just to waste the court's time. And it says the order of the court is effectively that all the parties, all the posters should be taken down. So, well, they don't have to be taken down. You can just, if you call it umkhonto, you can just scratch out the part that says wesizwe. I mean, really, are we here for that? The reality is that they wanted the party to be deregistered and they've failed. And there's nothing more your lordship or anybody can do about it. The voters on the 29th of May will have the choices and they will not be confused. It's an insult to our people to think they can be confused between some spear that's facing upward and another one that is in this fashion. So the last point, my lord, on Mr. My learned friend, Mr. Skakane, tried to make this point because of time. It's at page 15.9, I mean, paragraph 15.9 of Webster, my lord, Webster and Page. And it specifically deals with his section passing off. And it explains, but here's the punchline because I don't have time, my lord. It says, on that basis, this was the court, is the English court that my learned friend, the case is Kean, my lord, Kean, versus McGiven. It's an English case. Lord Eckner is quoted there, and then the author of this book says, on that basis, the court held that operating a political party is not an activity of such a nature as to give rise to an act of passing off. So it is neither an infringement of the act and neither a common law delict of passing off. Why? Because as far as the infringement is concerned, my lord, I've said it's mark for mark. And as far as passing off, it's logo for logo, if you like. And on the logo and logo basis, obviously they fail. But even on the mark-to-mark basis, with the green background, with the different warrior carrying the spear differently, with the words umkhonto wesizwe and MK at the bottom, those are distinguishing marks, my lord. And that is why my learned friend, and before I sit down, my lord, learned friend, Mr. Skakane, refers to what we state at page 155, my lord, which is this. And that really sums up the whole case. Page 155, paragraph 138. Because the part I read out to your lordship, which talks about clear right, actually talks about the requirements of interdict. And that's why I was saying it's cross-cutting between 134.1a and 134.1c. But this one talks about harm in the requirements of interdict. Here it is, my lord. There is no threat of irreparable harm to the ANC because the alleged voter confusion is imaginary and unproven. The emergence of the MK party is an act of disassociation, not an act of association. That's, if you read President Zuma's speech of the 16th of December, and by the way, I have news for my learned friends. You cannot attribute the speeches made by President Zuma to the MK party. They themselves say that President Zuma is not a member, or let me put it this way, there's no evidence that President Zuma is a member of the MK party. All he says is a voter like you and me who says, I'm going to vote for this party in terms of his rights under Section 19. He has never, and that's why if they wanted to rely on his utterances, they should have cited him. Because any voter in the taxi rank can wake up and say, I'm going to vote for the ACDP or whatever. There's no law that says that if you are a member of the ANC, you must vote for the ANC. That's an internal matter. If the ANC wants to take disciplinary actions, they must not ask the courts to do their disciplinary action. And my lord, the ANC has said that the ANC is the registered proprietor of the, I don't have time now to refer your lordship, but if your lordship go to their heads, you will find the following words. The ANC is the registered proprietor of the MK logo. Now they want to change their their case here because we have demonstrated that that is a fatal flaw. So they can't change their case, depending on the weather. The issue is that if they have come on the basis that they are the registered proprietor, then they must fail on that basis. As the court pleases, we are indebted to your lordship for indulgences. Oh, I'm sorry, my lord. But there's my learned friend, Mr. Skakane, wanted me to refer you to a case called Noni Multinational Brands. Noni, N-O-N-I Multinational Brands versus Beresford. It's 2021, neutral citation, 2021, Zaska 24, my lord, and specifically paragraph 29.
It's
Connie? Oh, my learned juniors write like doctors, not lawyers. It's Connie, not Noni. K-O-N-I, my lord, I'm sorry. Multinational Brands versus BS AG, something, it must be some German company. 2021, Zaska 24 at page paragraph 29. As court pleases. My lord, we therefore ask, my lord, that your lordship dismisses the claim, the infringement claim The passing off claim is actually, and your Lordship must be mindful that in the prayer of the infringement, they only talk about services. And in the prayer of passing off, it's incomplete, because passing off, you cannot get get an interdict. You get an interdict that says you cannot use this without clarifying and so on. So it's completely wrong. But more importantly, we would ask for punitive costs, my lord, on a cost on a punitive scale, because this is an abuse of our courts, and it must stop. Other would be infringers of our courts must be deterred, and we would implore your Lordship. There is no reason why Umkhonto weSizwe should be bankrupted by the ANC. Simply this day they take you to Bloemfontein. Let's say you are in Johannesburg. Now you are in Durban. For what? As the court please. As the court please.
All right.
Five minutes.